Hi guys, I want to do this video now while the situation is at a general standstill. On my old channel, I mentioned a legal defense strategy I came up with for NewJeans that never saw the light of day. Reason being they announced their re-debut as NJZ before I finished making that video. This decision from them made my defense no longer viable, and to be honest, that choice may have been what made them lose the injunction the way they did. A lot of mistakes were made along the way, but that one was definitely the biggest. What I want to do now is take a closer look at why they lost and find ways they can approach this appeal. I'll be showing a translated version of the ruling, but I'll leave a link to the Korean source in the description. I won't be going over the whole thing, just highlighting the parts I want to discuss. This is not legal advice, by the way, just my very unlicensed opinion and a bunch of yapping. ADOR argued that NewJeans' termination notice was invalid, meaning the contract was still in full effect. Allowing them to deny the agency's management rights would cause irreparable financial harm beyond monetary compensation. ADOR also highlighted dire implications this would have on the K-pop industry and their business partners. NewJeans' side argued that the contract was terminated due to severe breaches committed by ADOR. The agency has no grounds for the injunction, and granting it would infringe on the members' right to work and freedom of occupation. This would also cause the girls severe mental distress, while ADOR can be compensated financially for their claims. Injunctions are meant to minimize harm by dissolving or preserving the status quo while a larger case plays out. ADOR argued that they would face more harm if their management rights aren't preserved, because the damages they stand to face go beyond what NewJeans can pay to fix. NewJeans see this injunction as a violation of their human rights, with irreparable harm caused to them emotionally. The court sided with ADOR and agreed that even if they seek financial compensation in the end, it will be challenging to assess the exact amount of damages. What this means is the damages ADOR can claim from winning the lawsuit, in absence of this injunction, go beyond just a penalty fee. The ruling specifically highlighted potential damage to ADOR's reputation and the brand value of the NewJeans trademark. So basically, NewJeans may have to pay for any harm done to the company's image. They may have to pay for any harm their re-debut as NJZ did to company-owned trademarks. And there may even be a claim for ADOR's legal fees. That's before we even get to the independent sponsorships, performances, and other ventures they could pursue in the interim without an injunction. The ruling also pointed out that ADOR was established for the purpose of managing NewJeans, and they have no other artists. The girls knew this when deciding to terminate the way they did, and it's not a good sign that the court noted that. One may argue that ADOR could just debut another group, but the ruling sort of addressed this as well. The court acknowledged the high amount of capital invested to launch NewJeans and the extreme risk associated. Just make a new group is not a feasible solution, and most agencies would go bankrupt from an event like this. The court couldn't know this at the time, but NewJeans went forward with the complex con performance independently despite the injunction. The NJZ name was plastered all over, and merchandise was sold using it. I'm bringing this up because the ruling cited their plans to perform and release a new song independently as a reason the injunction was granted. They also unilaterally went on hiatus and gave interviews without permission from ADOR. This will make it harder to win an appeal, but they've seemingly reined themselves in recently and started making more calculated decisions. As I've mentioned in the past, injunctions like this usually favor the artist, and NewJeans could have achieved a different outcome if they weren't so reckless the first time around. I predicted a partial ruling in ADOR's favor because injunctions of this magnitude and nature never really get fully granted. After everything I read from the ruling, you're probably wondering why I think them specifically re-debuting as NJZ cost them this injunction. Well, my prediction included ADOR receiving royalties from NewJeans' independent activities, but not actually retaining management rights. NewJeans are entitled to freedom of occupation, and regardless of the circumstances, judges are hesitant to force artists to stay under management they don't want. However, the very nature of this injunction ruling means that maintaining ADOR's management rights was an absolute must to minimize harm. First of all, NewJeans did a re-debut press tour of large-scale international media outlets like CNN and blasted unverified claims about the company in front of the world. If the court is concerned about potential harm to ADOR's reputation, well, the only way to prevent that via an injunction is to ban unapproved media appearances. The icing on the cake is their re-debut name, NJZ, Honey admitted in an interview that they chose this name to preserve the essence of the original, NewJeans. Korean attorney Ko Sang-rok acknowledged this as a pivotal turning point in the case and described it as potential trademark theft. This likely prompted ADOR to expand the injunction, and HYBE probably saw this as an unacceptable line cross. My guess is the court realized this train had gone completely off the tracks, so a full-scale injunction was needed to stop the madness and restore some sanity. Fully granting the injunction empowered ADOR to protect the only asset it has left at this point, which is the NewJeans trademark. A precedent has now been set for future agencies who may go through a similar situation without the luxury of being backed by a conglomerate like HYBE. Guys, I could be wrong, but why would the ruling make it a point to say the girls knew their unilateral departure would devastate the company financially? The court could be raising suspicions of malicious intent or just irresponsibility. That's wild given the optics. They need to seriously sit down with their legal team and figure out how the hell they ended up in this position. I could be reading into things too much, but either way I'm going to account for this in my defense strategy for them. The goal of this defense will be to achieve the outcome I predicted the first time, which is royalties for the company without actual management rights. I believe this would fulfill the spirit of what NewJeans say they want, which is creative and professional freedom. It will also quell worries about ballooning damages because these royalties would eliminate the need to retroactively claim damages in the end. I don't foresee this injunction getting fully lifted, nor can I conceive of a strategy for that outcome. I think that would only be possible if NewJeans can showcase a material breach on ADOR's part in the main case. Denying this injunction would mean denying the contract is valid, and contracts are assumed valid until proven otherwise. Firstly, like I've told you guys in the past, going on hiatus was smart. Yes, it probably goes against the injunction, but it's the least bad of all the bad options in front of them. It signals to a judge that they are willing to sacrifice monetarily to get out from under ADOR's management. This means that they should be willing to share revenue with ADOR in exchange for freedom, and would also be willing to pay a penalty in the end if deemed necessary. Therefore, my proposed arrangement is feasible. My next suggestion is also something it appears they've done already, and that's throw the whole NJZ thing away. That was an unforced error that they will have to work very hard to reverse. Honestly, it's possible that it can't be reversed, but they can definitely try. They scrubbed all NJZ content from their Instagram and PR accounts, then changed the handle to their initials. This was smart, but it's not enough. Them or their legal team should make it clear to an appeals court that they understand why that name was potentially damaging, and they have no intention of using it again. They could even use Honey's confession as proof that the girls were not acting out of malicious intent, they just weren't aware they were doing anything wrong. Get rid of any suspicions that this was an attempt at theft and vow to use only their real names if the injunction is modified. They may not like this next part, but I feel it's necessary. They should accept some sort of gag order. If a judge gives them a break and modifies the injunction, he or she will probably want assurance they won't go on another press tour of unverified claims. Again, the court cited concern for ADOR's reputation as a reason they fully granted this injunction. NewJeans should vow not to discuss the ongoing case in the media until legal proceedings conclude, and naturally ADOR should do the same. This further relaxes the need for ADOR to maintain management rights and calculate additional damages in the end. Please keep in mind that the injunction is separate from the overall lawsuit. You guys know my stance on this case. NewJeans should just settle with the company. I've been saying it for months now, and even the judge suggested this at the first hearing. This video was solely about the injunction appeal and my personal opinion on what they should do. They've dug themselves into a hole, so they could do everything I suggest in this video and still lose the appeal. I think they have a good chance of getting it modified at least. I mean, I thought they could have got it partially dismissed the first time. They are fighting an uphill battle, though, and I hope this reality was explained to them by their lawyers. This injunction was the legal version of a checkmate. Any move NewJeans can make at this point holds potential consequences. I just hope for a fair outcome for everyone involved, whatever that may be. Anyway, that's my take. Thank you all for watching. I'll see you in the next one.